Hello, I'm Kenneth Marcus, the Assistant Secretary for Civil Rights in the U.S. Department of Education's Office for Civil Rights. The mission of the Office for Civil Rights, or OCR, is to ensure equal access to education and to promote educational excellence throughout the nation through vigorous enforcement of civil rights. OCR's enforcement jurisdiction includes Title IX of the Education Amendments of 1972, commonly referred to as Title IX. That law prohibits sex discrimination by recipients of federal funds, which includes most colleges, universities, and public elementary and secondary schools. Title IX requires schools to respond appropriately when they learn of sexual harassment in their educational programs or activities between students, or between an employee and a student, or even between an employee and another employee. The Department's recently released Title IX regulations are designed to create a consistent, reliable, and effective means of securing non-discrimination in schools while also protecting due process and free speech rights. This is the first time in history that protections against sexual harassment have been enshrined into federal education regulations. Before now, schools and students were subject to guidance documents that lacked the force or effect of a law. But students alleging sexual harassment deserve more than just non-binding guidance letters. They deserve to be protected by the law. In this webinar, my OCR colleagues and I will explain many of the new protections provided to individuals who allege sexual harassment, including sexual assault under OCR's new Title IX regulations. We hope that you will see the new ways that these regulations support students alleging sexual harassment and protect their privacy while also respecting their autonomy. The regulations were announced on May 6, 2020, and the new protections discussed in this webinar, like the other provisions of the rule, are effective on August 14, 2020. OCR's new regulations provide a new definition of sexual harassment that schools must use for Title IX purposes in order to protect students from sex discrimination. For the first time, OCR is defining sexual harassment to include even a single instance of any of these serious forms of sex-based sexual harassment: sexual assault, dating violence, domestic violence, and stalking. Previously, OCR analyzed whether such conduct was sufficiently severe or pervasive to be covered under Title IX. No longer will OCR evaluate whether sexual misconduct of this nature meets severe or pervasive threshold before Title IX protections are triggered. Now, each of these forms of sexual misconduct will constitute a per se incident of sexual harassment when they are based on sex. By defining sexual harassment to include these forms of sexual misconduct, Title IX will cover a wide range of serious violations of a person's bodily and emotional autonomy, regardless of how many times a specific type of incident occurs. Sexual assault incidents include not just rape or attempted rape, but any instance of forcible or non-forcible sex offenses. The crimes included in our definition of sexual assault do not require physical force or violence, but rather are based on the lack of consent on the part of the victim. Importantly, the Department's Title IX rule recognizes the reality that sexual assault is often perpetrated by persons known to the victim. Our definition also includes sex-based dating violence, domestic violence, and stalking as defined by the Violence Against Women Act, which are serious problems affecting all students, especially college-age students. Let's talk specifically about dating violence. No longer will students or their loved ones have to wonder, before they report to a Title IX coordinator or other school official, whether violence between people who are in a dating relationship counts under Title IX. And no longer will they have to wonder whether they have the power to report dating violence taking place in a relationship. As you will hear in a moment, the new Title IX rule permits anyone to file a report of sexual harassment even a friend or other bystander. In addition to dating violence, stalking based on sex is also a serious concern that presents a unique risk to the health and safety of college students. Our definition of stalking includes any course of conduct directed at a specific person on the basis of sex that would cause a reasonable person to fear for his or her safety, or the safety of others, or any conduct that would cause a reasonable person to suffer substantial emotional distress. The new Title IX rule covers many instances of stalking based on sex, including stalking that occurs online or through messaging platforms, commonly known as cyberstalking, when it occurs in the school's education program or activity. Like sexual harassment in the form of dating violence, the new Title IX regulations make clear that even a single instance of such stalking constitutes sexual harassment. I'll now turn to my colleagues to describe the new Title IX protections for complainant autonomy.
In the past, OCR required schools to always investigate any report of sexual harassment, even when the complainant did not want an investigation or a grievance process. Under the new process, students will now have greater control over whether to file a formal complaint against anyone who sexually harasses them. As Assistant Secretary Marcus has indicated, anyone, including bystanders, may report sexual harassment and put the school on notice. When a school learns that someone is alleged to be a victim of sexual harassment, the school must promptly contact the person and inform them of their right to request supportive measures, whether that person decides to file a formal complaint or not. During this process, the school must consider the alleged victim's wishes and must offer appropriate supportive measures under the circumstances. The Title IX coordinator must also now explain to complainants that they have an option and a process for filing a formal complaint. If a complainant or their parent or guardian signs a formal complaint, or the school's Title IX coordinator signs a formal complaint, then the school must follow the grievance procedures required by the rule. The school must offer the complainant supportive measures regardless of whether a formal complaint is ever filed. A school may never pressure an individual into filing a formal complaint or into participating in a grievance process. Similarly, a school may never pressure an individual into not filing a formal complaint or participating in a grievance process. This helps protect a complainant's autonomy and gives complainants and other students more control over how their school responds. Once filed, every formal complaint must be investigated by the school. We received stories from survivors who were told by their schools or teachers that no one would believe them. Some allegations were not taken seriously by school officials, and that lack of action caused students to drop out of school to avoid their attackers. Some students told us that the Title IX coordinator appeared biased in favor of respondents. And a recent OCR investigation revealed that one large urban school district failed even to have a Title IX coordinator in the first place. We heard stories from victims who were subjected to long-term abuse by teachers and professors. We also heard about troubling instances where the school's priority was protecting the reputation of the university rather than protecting students. Under OCR's new rule, every formal complaint must be taken seriously by the school, and every complainant must be supported. The school now must include in its written grievance procedures the range of supportive measures offered by the school. Importantly, A student who has chosen not to file a formal complaint is entitled to supportive measures irrespective of whether a grievance process is pending. Every school must still designate at least one specific employee, called the Title IX coordinator, to ensure that the school's response to sex discrimination complies with federal law. The new rule expands a school's obligations to ensure its educational community knows how to report to the Title IX coordinator. In addition to stories from victims about the failures of some Title IX coordinators and the difficulty of reporting, past OCR investigations have found that colleges violated Title IX because the person identified by the school as the Title IX coordinator was unfamiliar with Title IX, had no training about Title IX, or did not even realize that he or she was the Title IX coordinator. Students deserve better. Further, in addition to the existing requirement to provide the name or title, as well as the contact information for the Title IX coordinator to students and employees, this information also must be posted on the school's website and must now be provided to all applicants to a school, all parents or legal guardians at the elementary and secondary school level, and all unions or other professional organizations that have a collective bargaining agreement with the institution. The rule requires schools to not only designate the Title IX coordinator, but also to authorize that employee to do the job of a Title IX coordinator. The rule vests important responsibilities in the school's Title IX coordinator, including responsibility for effectively implementing supportive measures and remedies for victims of sexual harassment. The rule ensures that anyone, and not just the victim, is able to report sexual harassment to a Title IX coordinator 24 hours a day by mail, phone, or email. Once a report is made, a school must promptly respond and cannot wait until the student misses classes, drops out of school, or suffers other tangible negative consequences. It is important for complainants to also know that the new rule expands required training on Title IX. Now, Title IX coordinators, investigators, and administrative decision makers, as well as anyone who facilitates an informal resolution process, must receive training on the key elements of Title IX, including the definition of sexual harassment, the scope of the school's education program or activity, how to prevent irrelevant questions about a party's sexual history from being asked during a hearing or other proceeding, and how to conduct an investigation and the grievance process, including the use of any technology to facilitate a remote hearing.
The new regulations also include prominent features that protect important aspects of complainants' privacy. The department heard from survivors of sexual harassment who said that they were worried about the public nature of Title IX proceedings and feared the stigma and backlash that went with filing a formal complaint. The new regulations require schools to adopt written grievance process and abide by those written procedures, stating that the school will never use or attempt to use questions or evidence that is protected by a legally recognized privilege, unless the person holding the privilege waives the privilege. That means the attorney-client privilege, a patient-physician privilege, or any other privilege recognized by law. Under prior Title IX policy, there was no bar against a school seeking or using this information. In the same vein, the school cannot unilaterally access or consider a party's records if those records are made or maintained by a physician, psychiatrist, or other recognized professional and made for the purpose of providing treatment to the party. These records can only be accessed with a party's voluntary, written consent. On the other hand, complainants and respondents will no longer be barred from reviewing relevant evidence. Another new protection is that, during the grievance process, questions or evidence about the complainant's prior sexual behavior, even with the respondent accused of sexual harassment, and even in cases where the respondent already possesses evidence about sexual history, are never deemed relevant, with only two exceptions: to prove consent or to prove someone other than the respondent committed the alleged sexual harassment. As noted earlier, a school must ensure that all decision makers, investigators, and the Title IX coordinator receive training on issues of relevance, including applying rape shield protections for complainants. This short video has touched briefly on many topics. We have explained these regulations and their codified protections for complainants in another, longer webinar, as well as a series of explanatory documents. To learn more about these topics and the entirety of the department's new regulations, please visit www.ed.gov/OCR. If you have questions regarding the department's new regulations, please send them via email to t9questions@ed.gov. Anyone who believes that a recipient has violated a federal civil rights law enforced by OCR can file a complaint online at ocrcas@ed.gov. Links to these sites and other information are posted in the video description.